Hi there. This is Laura's digital assistant. She is always busy selling homes and helping clients, so I hope you don't mind me helping her. Before that, for sale sign goes in your yard. Let's walk through the listing agreement, one of the most important documents you'll sign when you hire us to sell your home. I'm going to break it down for you clearly so you know what you're agreeing to, why it matters, and how it protects you. Paragraph 1. Who's involved? This is the section that names you as the seller and our team, the Blessed Life Group with Keller Williams Realty, as your exclusive listing agent. We've been helping clients sell homes across the Austin area and surrounding communities for years. From Cedar Park to New Braunfels, we know the neighborhoods, the trends, and how to price and market your home right. Paragraph 2. What's included in the sale? This outlines what's being sold: the land, the house, any attached items like lighting, appliances, and built-ins, and even accessories like garage remotes and curtain rods. This is also where we validate if the property is in an owner's association or not. If there's something you want to take with you, like that custom chandelier or a smart home device, we list it here so there are no surprises later for the buyer. Paragraph 3. Listing price. We'll work with you to set a listing price based on recent comparable sales, neighborhood trends, and our deep understanding of the Austin metro market. Depending on how much work there is to do before you list on the MLS, the market may change, hopefully in your favor. We will want to confirm this price with you before we officially list it on the MLS, and we do not do this without your approval and checking the listing information we have drafted. Paragraph 4. Term of the agreement. This is the start and end date of our agreement. Most listing terms are 180 days depending on your goals. But I want you to know, we believe in earning your trust. If you're not happy, we include a clause that allows you to cancel the listing with a simple email. Paragraph 5. Broker compensation. When you list your home with the Blessed Life Group, our approach to broker compensation is built around one thing: your success and your choice. In paragraph 5B of the listing agreement, we fill in A, 3%, our base professional fee. B, C, fee structure attached, because you deserve more than a one-size-fits-all model. We've offered a flexible fee structure since 2013, and it's designed to protect your equity, give you options, and ensure you only pay for value. That's why our clients keep coming back and sending their friends and family our way. Why we use paragraph 5B, not 5A. Paragraph 5A is traditionally used to define upfront broker compensation split with a buyer's agent and posted into the MLS. But due to the recent lawsuit settlement, sellers are no longer allowed to advertise buyer-agent compensation in the MLS, and we believe that's a good thing. Instead, we use paragraph 5B and attach a fee structure that reflects your options and keeps you in control. If a buyer's agent includes compensation in their offer, we'll advise you based on market conditions, number of offers, and buyer demand. We'll help you determine if offering that fee serves your best interest, and we'll ensure you approve any concessions or fees in writing before they're paid. If a buyer's agent calls in advance and asks about compensation, we will disclose only that the seller is open to discussing it, but we won't give them a number unless you've directed us to. This paragraph also includes when compensation is earned and payable. It's important to know the difference between earned and payable. Our compensation is earned when you sign a contract to sell your home. We procure a ready, willing, and able buyer. Or if you breach the listing agreement by not honoring its terms, our fee becomes payable. At closing, once the sale is funded, or if you decide not to sell after we've already procured a buyer, or if there's a breach that causes the deal to fall through, we are not paid. If the sale doesn't close due to no fault of yours, like a casualty loss or a title issue, a buyer fails to close, and you don't collect damages. Other compensation scenarios. The agreement also outlines other situations where compensation may be due. Buyer breach. If a buyer backs out and you collect a settlement or damages, we may earn up to half of that recovered amount after legal fees, not to exceed our original fee. Referral fees. If we refer a service provider, like movers, contractors, or utilities, we may receive a referral fee from them. It doesn't affect your net or add cost to your transaction. Protection period. What it means for you. Here's a big one most sellers overlook: the protection period. This is a time frame, usually 30 days after our agreement ends, where we still may be owed compensation if we procured a buyer during the listing period, and you sell to that buyer after the listing ends. Why? Because we did the marketing, showed the home, answered their questions, and invested time and energy to bring that buyer to the table. You'll receive a written list of those buyers before the protection period starts, so you'll know exactly who's included. Paragraph 6, marketing your home. We agree to publicly market your home, meaning we list it in the MLS, syndicate it to sites like Zillow and Realtor.com, and showcase it on social media, email campaigns, and more. And we take it up a notch. Our listings often include professional photography, staging guidance, compelling descriptions, and personalized strategies based on your property type and ideal buyer. We will not list the home publicly until you give us your approval and review the listing information. 7. Access to the property. We use secure key boxes and professional scheduling systems so you always know who's showing the property. You're in control of availability and will work around your family's needs. You also agree to hold the broker harmless from any claim for personal injury, property damage, or other loss, except for a loss caused by the broker. We require a phone number for anyone that enters your property and keep a record for you. 9. Intermediary status. Intermediary status is required to be addressed in every Texas listing agreement, and it's something we walk through with each seller to make sure you understand exactly what it means. By allowing intermediary status, you're giving us permission to market your home not only to the public, but also to other agents in our Keller Williams office, and even to buyers we may already be working with directly. That's a good thing. It opens more doors for potential offers and gives us the chance to leverage buyer relationships we've already built. If one of those buyers wants to purchase your home, we'll notify you immediately. You'll get to choose how we proceed, and we'll put that decision in writing. In most cases, we recommend appointing another associate, someone else on our team, to represent the buyer, while I continue to represent you. This allows both parties to receive advice and negotiation support while complying fully with state law. And to be clear, we will never represent both sides ourselves in the same transaction. That's not allowed in Texas, and it's not how we operate. At the Blessed Life Group, our job is to protect your best interests, always. If the opportunity arises to sell your home to a buyer we or our office represent, we'll guide you through it step by step, keep everything transparent, and make sure you feel supported and fully informed. Paragraphs 10 and 11, confidentiality and our role as your broker. When you list your home with the Blessed Life Group, your privacy matters. Paragraph 10 of the listing agreement confirms that any information you share with us about your finances, your timing, personal reasons for selling, or anything else sensitive stays confidential. We will never disclose that information unless you give us approval or we're required to by law. Paragraph 11 section lays out what we're actually authorized to do as your broker and how we help you behind the scenes. Here's what we're empowered to do on your behalf. Market your home across all platforms: MLS, social media, Google, Zillow, print materials, you name it. Place signs and run digital advertising campaigns to generate interest. Coordinate with buyers and their agents, lenders, appraisers, title companies. You don't have to chase anyone down. Communicate with showing agents, collect feedback, and keep everything moving toward an offer. And once we're under contract, we help ensure everything stays on track to close smoothly. We do not have authority to sign contracts or make binding decisions on your behalf. You stay in control, and everything flows through your approval. Also, if you've checked the boxes to allow your home to be marketed online, that includes photos, videos, floor plans, virtual tours, and pricing, and the types of financing we will market. You still retain ownership of anything you provide, but we retain rights to anything we produce, like our professional photography, video tours, and marketing copy. Paragraph 12, seller's representations. This section is where you, the seller, confirm a few important things: that you own the property and have the legal right to sell it, that you're current on mortgage payments, property taxes, and HOA dues, that you're not under contract with another real estate broker, and that there are no pending legal disputes, liens, or ownership issues we should be aware of. You're also confirming that you'll be honest about the condition of the home. If there's something you know that could affect the value or safety of the property, like a past foundation issue or a roof leak, we need to disclose it. Not only does that help us market it accurately, but it also protects you from liability after closing. Paragraph 13. Seller's additional promises. This is your agreement to work in partnership with us. It includes things like giving us access to the property for showings, not negotiating directly with buyers, just send them our way, letting us know if you rent it out or if any new leases are signed, updating us if anything changes, condition, financing, timeline, etc. It also asks that you complete and update all required disclosures. For example, if you fill out the seller's disclosure notice and then a pipe bursts, let us know so we can update it. Ultimately, this section ensures we're on the same page and working together to keep things moving smoothly and ethically. When we're aligned and informed, we can represent you with confidence. These sections help us protect you, avoid surprises, and present your home in the best possible light, while staying fully compliant with Texas Law Paragraph 14. Limitation of liability and safety. Selling a home comes with a lot of moving parts, and safety is always a priority for you, your home, and everyone involved. If your property is going to be vacant during the listing period, we strongly recommend notifying your insurance provider. They may need to update your policy to ensure proper coverage. While we take every precaution with showings and access, using lockboxes, tracking appointments, and vetting buyers, it's important to understand that we're not liable for any damage, theft, or injury caused by third parties during the listing period. This section simply clarifies that responsibility, and it's standard in all Texas listing agreements. That said, our job is to manage the process with professionalism, care, and communication. We'll do everything in our power to keep your property secure and the transaction stress-free. Paragraph 15. This section is called Special Provisions, and in our listing agreement, you'll see a simple but important sentence added here. You can cancel this agreement at any time with an email notification. We believe real estate is a relationship business, and that means trust, communication, and alignment matter. If at any point you feel like we're not the right fit or that something's not working for you, please don't wait until the agreement ends. Just let us know and we'll release you from the agreement. No pressure, no penalty. We're confident in the service we provide, but we also believe in doing what's best for you. And if you'd like, we'll even help connect you with another agent who might be a better match. Your goals always come first. Paragraph 16. Default. This paragraph covers what happens if either party doesn't hold up their end of the agreement. If you, the seller, breach the listing agreement, for example, by not cooperating with us to allow showings or by selling the home without involving us, you could still be responsible for the broker's compensation outlined in paragraph 5. On the flip side, if we as your broker don't follow through or fail to perform our duties, you have the right to terminate the agreement and pursue legal remedies. This section is here to protect both of us and reinforce the professional standard we operate under. Paragraph 17. Mediation. We always aim to handle issues professionally and with mutual respect, but if a dispute were to arise between us that we can't resolve through conversation, this paragraph states that we'll agree to go to mediation before pursuing legal action. It's a fair, neutral, and often faster way to resolve misunderstandings if they happen, and it's part of our commitment to keeping this process respectful and reasonable. Paragraph 18. Attorney's fees. This section says that if a legal dispute does arise and goes to court, the winning party is entitled to recover attorney's fees and costs from the other party. We've never had to go there, and we hope to keep it that way. But this clause is a standard legal protection built into most contracts. Paragraph 19. Addenda and other documents. This is where we list all of the required addenda that will be attached to the listing agreement. That might include The information about brokerage services form wire fraud warning. Your seller's disclosure. Notice any required MUD or PID notices, and if applicable, disclosures about lead-based paint, HOAs, surveys, or on-site sewer systems. We'll go over exactly which ones apply to your property and make sure you're fully covered and compliant. Our job is to make sure nothing gets missed and you're legally protected. Paragraph 20, Agreement of Parties. This section simply states that the listing agreement is the entire agreement between us. It can't be changed unless we both agree in writing, and it can't be assigned to someone else without mutual consent. That means everything we agree to is right here, in black and white. Nothing is hidden, and you're fully protected. It also says that if there are multiple sellers, each of you is equally responsible for carrying out the terms of the agreement, and if any small part of the contract were to be found invalid, the rest still holds. Paragraph 21, Additional Notices. This section gives you a few final reminders that are especially important when selling a home. Fair housing. We follow all fair housing laws, and your home will be marketed equally to all qualified buyers, regardless of race, religion, gender identity, or any other protected class. Home security. We recommend removing or securing valuables, prescription medications, firearms, and sensitive information during showings. Surveillance devices. If you have cameras or recording devices, please let us know. Laws around recording vary, and we want to protect both your privacy and buyer's rights. Lead-based paint. If your home was built before 1978, federal law requires a specific disclosure and informational pamphlet for buyers. We'll help you handle this if it applies. Foreign sellers. If you're a non-U.S. citizen or classified as a foreign person by the IRS, there may be tax withholding requirements. If that's the case, we'll flag it and recommend a CPA familiar with FIRPTA. These aren't just fine print. They're thoughtful reminders designed to help you stay compliant, protected, and stress-free throughout the selling process. So that wraps up the full listing agreement, start to finish. Our goal is always to make sure you understand exactly what you're signing and feel confident, informed, and supported from day one. If you ever have questions, just ask. We're here to walk you through every step. Second document, General Information Notice for Buyers and Sellers. This is a broad educational document, and it's gold. It outlines a lot of key info about the process of buying and selling, things like what's involved in appraisals and inspections, how agency relationships work, disclosures like flood zones, mineral rights, and property taxes, what to know about insurance, foundations, and environmental issues. It's meant to make sure you're fully informed so you can make empowered decisions. Third document, Wire Fraud Warning. This one is all about protecting your money. Sadly, wire fraud is real in real estate. Hackers can mimic title companies or agents and trick people into wiring money to the wrong account. We include this notice to remind you, never send financial info over email or text. Always call the title company directly at a known number before sending any money, and know that our team will never ask you for wire instructions over email. Fourth document, Affiliated Business Arrangement Disclosure. This is about transparency. It lets you know that Keller Williams and some of our partners may have business relationships with title or mortgage companies. That includes Texas One Title, Primrose Title, and others. You're never required to use any of our affiliates. You're free to shop around. We just want you to be aware our focus is always on doing what's best for you, and we work with whichever professionals you feel most comfortable with. Selling a home is a big move, and these documents are here to make sure it's done right, safely, and legally. If you have questions about any of these forms, our team is just a call or text away. We're here to guide you with clarity, care, and strategy every step of the way.